you the documents that we had.
And I haven't seen them, and I don't have time right now. Okay, here we go. There we go.
I can see it's gonna be a long night. I ain't gonna stop until I get it right. I don't wanna sing no Jeremiah. I'd really love to say things just ain't that bad. Oh, how we love our denial, a comfort to cover up the shame. But the truth is standing on trial, and I've got proof that we're all to blame. Oh, my fellow Americans, are we reaping our harvest of greed? Have we built our house on sinking sand? Why are we being ugly Americans?
Welcome to Homeowners for Justice. This is CJ Holmes. I'm the founder and host today for Weekdays Live. And breaking news, we have Mary from North Carolina on the phone right now. You got to hear this. Share with us what you just called me this morning about.
Okay, CJ, we're really excited. I think we had a hearing this morning on a case. It was an appeal to a foreclosure. And before the foreclosure, about 2 weeks ago, we sent a letter to Bank of America, to the trustee, and to Bank of America's legal counsel, Bank in Rome. You've probably heard that name before. The evidence that we had in the file, and we laid it out with no stone unturned. We found the robo-signers. There's no assignment on the note. This was a Taylor, Bean, and Whitaker case. So if you're familiar with what happened there, Lee Farkas is in prison for 30 years for mortgage fraud. He was selling over and over, and sometimes there was nothing behind them. They were just pieces of paper. So the government went after him, found him guilty, and put him in jail. So this morning the hearing that we had was with Bank of America, supposedly the servicer, but they had identified themselves in all the filings with the clerk's office as if they were the note holder. Over and over, every document they filed, Bank of America was a note holder.
Right.
We did the QWR.
Right.
OCC complaint, and based on the information we were put together from those two things, we caught them. We caught them red-handed. We caught them with robo-signers. We caught them with fraudulent affidavits they had filed with the Register of Deeds. They even admitted to us that Jenny Mae was a note holder, which Jenny Mae can't be a note holder. So we had everything. And we sent them a letter 2 weeks ago, and we detailed everything we had, along with all the fraud, the signatures that were there, and just laid it out. So we had the foreclosure appeal hearing today, and nobody showed up.
Oh, wow, that's fabulous news.
It is. And I think we probably had some issues with procedure, because we were going to go for a motion to dismiss, but we hadn't had time to really serve it on the other side, so the judge didn't hear it. So, but the action has been taken off the calendar according to the judge. Nothing can happen now until whatever. We don't quite understand exactly what he did, but he said it's off the calendar.
Right.
It can happen now. We just have to wait it out. We don't know what that means.
Right. And let me just interject right here. Now, you're in court, right? This is a lawsuit that you've been working on because...
we haven't filed a lawsuit. They've just filed a foreclosure. This is a non-judicial state.
Okay, so they filed a foreclosure and you fought back in court?
Yes.
Okay. And you basically filed a wrongful foreclosure case?
No, we haven't filed anything. We've just defended the foreclosure they filed. We just contested the foreclosure they filed.
And what you did was detail everything like we've been talking about here on this show, of getting the notary, filing notary complaints, getting those signatures, comparing them, proving they're not the same, proving that the notarizations of the signers are false. Which we use the word fraud or forgery, but suspicious documents. I think we've agreed that that's what we should say, and you detailed this case, if you will, almost like what I've been terming an owner's affidavit, just a list of all of the violations, and you sent that to B of A.
Yes.
And where else did you send that?
We sent it to Bank and Rome, and we sent it to the trustee.
Okay, so you have not yet sent it to the Attorney General in North Carolina.
Well, our Attorney General is not listening to our complaints. They're turning them down.
Okay.
So we have gone to our senator.
Okay, so you're sending them to friendly people, and I'm going to recommend, and this is fabulous lead into the show today, because today, we're gaining ground. We really are, but we really need to press the advantage to actually get the foreclosure machines to stop, because here B of A is defaulting, and now the foreclosure is off the docket, but that's for that particular house, right?
Yes.
And there's nothing to keep them from stealing other people's houses.
Yes.
As individuals are fighting, but the machine, it's like a headless machine just mowing down the owners and taking the properties, and they'll take whatever they can get. I know that.
Well,
So
something else that we're doing, CJ, too. We're going to start holding the clerk of court speak to the fire and the register of deeds. We have formed a task force.
good.
Foreclosure fraud task force. And we're going after them. We're not sitting back any longer and just letting this happen without putting everybody on notice. We're done. We've had enough. We're moving forward.
Right.
We're going to have a meeting hopefully this week because we've got some statutes on the books that actually say if we can charge them with willful neglect or in discharge of their duties, it's a misdemeanor, class 1 misdemeanor, and we can actually have them arrested.
Okay, so listen up, everybody, in every state nationwide. I
We're
know.
gonna go for the juggler.
I know we have those statutes somewhere. Somebody needs to help us find them, and those are the ones that I want to have put into the owner's affidavit. And Mary, take my advice. If you go to my notary complaint page, I don't know if you've had a chance. I mean, everybody is so busy, but we're recommending that each of these complaints, we sort of wrap up, the entire list of complaints per property, and the owner notarize that to the best of their understanding, and then a copy of that is sent to the recorder, the district attorney, the county sheriff, every county supervisor, the attorney general, and then at least one major media outlet. I'd recommend 2 or 3. Let's pick New York Times. Let's pick the San Francisco Chronicle. Let's pick CNBC News, CBS. I don't care. Let's send them everywhere because.
Let me make one other point, and I'll let you go because I know you got a good show coming up. Another thing that we have come to the realization is on this fiduciary trustee relationship. Today, the appeal was filed with the trustee because their name was on the papers. The trustee cannot in any way, shape, or form show up in any courtroom now to defend anything. That is against the law because they are a trustee and have a fiduciary responsibility to us and the bank.
So you're talking now about the foreclosure trustee mill.
Yes, I am. We've put them on notice. There's nothing they can do at this point because we know where the fraud is. We have contested the foreclosure, and they're out of the picture as far as being able to defend it for anybody. They can't speak on behalf of the bank or us or the homeowner because of their fiduciary responsibility. So we've put them in a little box and said you can't come out and play anymore. Now,
Mary, is that fiduciary responsibility? Is that in your statutes?
Yes, it's actually in the Clerk of Court's manual, and it's quoted exactly from the statutes.
clerk of...
I'll
Okay,
send
so...
you a copy of that also, because I've
Okay.
already detailed that out.
Thank you, because everybody is fighting. I know that Renee and Randy have been reading through the recorder's manual, and we're looking for every angle we can use to box the master servicers. It's basically the mega banks that we're after, and box them so that we can actually, cut them off at the knees,
Yeah,
just
we've
like
done
what's
that. We've
happened.
done that because of fiduciary responsibility. We have CPR, which is Code of Professional Responsibility 166, which the bar attorneys have to abide by. And that 166 opinion from the bar says the same thing. They cannot go into a court and defend anything for the bank.
Right, even though they are a bank wholly owned subsidiary.
Yeah, we've basically cut them off at the knees from being able to defend anything. Because at this point, we've got them on notice of what their job is, and we dare them to come out of that box.
Okay, so all of us listening, let's make a point of this. That was in your professional code?
Yeah, Professional Code of Conduct for the Realtors for the Bar Association.
Okay.
Ours is 166, but you've got one similar, I'm sure.
I'm sure we do. I'm sure we do. We just need to know where to find it, and that's why I'm making a big point about this, because I know we have a core group of hard-hitting people.
I'm detailing that in our clerk's manual.
Yes.
And and my next step is to write a letter to our clerk, laying out the law to her in her own manual, and say, dare step over this line again.
Right,
Okay.
right, which is what we want to do everywhere. So if you can just keep us in the loop with the documents, the codes for North Carolina, then we know sort of where to look. We can try to duplicate this for each state around the country.
Yes, yes.
Thank you so much for this good news, and I'm telling you, it feeds right into our headlines.
Good. And the other thing,
yeah.
Elizabeth Warren, I saw your note about her. I contacted her office last week.
Thank you. And I contacted her office over the weekend. You have to go by the website, the email and stuff. And I just said, please, we want to support you. Connect with the people in the country that are willing to give you this political force. And that's what we need to do. Thank you so much for sharing with us this morning, Mary.
Quite welcome.
Okay, and we hope to hear from you soon. And she's already said she's sending all the docs. I haven't seen them yet, but I will definitely work to put that together so everyone around the country in every state we can, not have to duplicate the effort, but we can coordinate our efforts and, focus the few time resources that we've got, because everybody's super swamped, to try to make the best use of it that we can.
Absolutely.
Thank you so much.
You're doing.
Okay, thanks, Mary.
Okay, bye.
Bye. Now, that moving right into the headlines, we're gonna listen to that Texas audit video. It is fabulous, and then I'm going to show you some things that he talks about in there. Like he talks about the exceptions to a preliminary title report. It's super. It's amazing. And Anonymous has sent out a message. I want to share with you what they're doing and what we can do to really, kick our effort up into high gear. And then we definitely need to see what's happening at the federal level. We're moving from Geithner to Lou. Is that from bad to worse? We'll see. You guys will make that decision. And then who we can connect with. I'll show you some flyers that are being mailed out, some information about persuading our attorney generals and other recalcitrant officials, and how do we connect with Democracy Now! So without ado, we've just got to move right into the Texas audit video. It is something else.
It's a sad thing for homeowners. It's a sad thing for people who are making their payments and doing everything that they normally expect to do, and they expect the banks to follow through, and it's not happening. The trust factor is gone as far as I'm concerned. So, you just keep your fingers crossed that everything's going to work out right and you get your home paid off and it's all over with. But like you said, 6 years later, this homeowner was foreclosed on?
Yeah, they're being foreclosed on at the present time. And they had paid their loan off and got a note that said paid in full.
One of the great things about living in Williamson County or Travis County is you have a very easily accessible, very user-friendly electronic database that the county maintains. that allows you to go in and learn a lot about what's going on with your particular home loans. So you can go to the website that Clerk Reister has set up, and you can say, enter in your name, find out what has happened with the deed of trust that's been recorded. Now, one of the things we've talked about is the problem of things not being recorded. But looking at the recorded records can very often give you a real good start to find out what to do next. If you see something that looks irregular, find a lawyer. I think, Attorney General Holder and the other people who were behind this in the first place had good intentions. Now, I think they wanted to make the system more efficient, but they cut corners. And I know in the age of TARP, it is astonishing to think of banks cutting corners. But I think maybe they did a couple of times. And, it's causing people to lose their homes when they shouldn't. It's causing the county to lose millions of dollars, nationwide, billions of dollars in recording fees that aren't being paid. And that was MERS' original pitch in their business model. We're going to save you $16 per document. Doesn't sound like much, but when you talk about 70 million mortgages, each one with 4 or 5 documents, okay, now you're talking about 500 million documents, $16 a document, that's $8 billion. That's real money. Well, one of the things you look for is, has my note been assigned more than once? Okay, if the deed of trust has been assigned to one bank and then subsequently the original assigner is assigning it to another bank, that's a big red flag. Are there gaps in the chain of assignment? That is, your original lender, say in this instance was Fieldstone, and they transferred it to LaSalle, and then there's no record of LaSalle transferring it to anybody else, and then there's a transfer from Wells Fargo to US Bank. That's a big red flag.
When you want to go sell that house, the title company wouldn't know who to pay off because there's a missing link there and they don't know.
It's something where there's a joint responsibility. I mean, the county clerk's hands are tied to some extent. They have got to file, by law, any documents that are presented to them. Even if the documents come in and they're like, we think this document's really fishy, they have to file it. Now they can, if they're firmly convinced that it's a fraudulent document, then take that document to the county attorney and ask them to file a suit to get that document removed. But
now electronically, we don't have quite those. We don't know about the notary. It's all black. Everything is black, so we just assume that whoever's sending it to us is sending it to us properly and it's been done correct. And that's the title company's job at this point. Now, I know in the legislative session right now, they are going to try to open that up to more people to be able to file with us. Because presently, over half of our documents are filed electronically. So some of those safeguards are slipping away. Numerous calls from folks going, okay, I've looked this up. I'm calling Wells Fargo because that's who I make my payments to, but they're not on an assignment on my note. And I've called them and they're not doing anything. What do I do now?
There are some specific things that are authorized by statutes, both federal and state statutes. The Texas legislature, in its wisdom, passed a variation of the Business and Commerce Code that allows you to send a letter to ask for specific information from the lender. And if you invoke the Business and Commerce Code 9-210 of the Texas Business and Commerce Code, that's a good place to start. A qualified written request under the Real Estate Settlement Procedures Act, the federal government has authorized that. If you send those to your lender, they're required by statute to respond and give you some information, and that can kind of get the ball rolling. The Better Business Bureau can be a valuable resource, especially early in the process. You're not in danger of foreclosure, but you have a lot of questions about what's going on with your loan. If you contact the Better Business Bureau, they can very often arrange mediation or give you some guidance, and they can tell you, for instance, if lenders have bad ratings with them or especially good ratings with them, and that can be helpful information as well. There may be liability for title insurance companies, and I know that there's at least one large title insurance company, Dave, you were telling me the name of it last night, that has now refused to issue any more policies on MERS loans.
Right, that would be Old Republic Title, Old Republic National Title Insurance Company. Old Republic has, it's amazing how through the course of writing the book, I came into contact with, in title companies like Alamo Title, refused to talk to me. They said, you're trying to put us out of business. I said, oh no. You're going to do that to yourself. I'm not going to be the one doing it. You guys will slip up. I said, when you issue, and that very question was asked of me when I was at clerk school a year ago, January, and a clerk asked me, and the jaws were dropping around the room. She said, how is it that the title companies can issue policies knowing that all this stuff is out there? And I said, well, they simply write around it. And the clerks are like, what? I said, if you look back in Schedule B, under exclusions, it says we don't cover anything that's not in the public land record. You know, part of the business model is that there's no regulatory oversight for MERS, and it allows abuse by its membership to do whatever they want and run willy-nilly, and MERS just says, we didn't do anything wrong, and MERS technically is right. They didn't do anything wrong except create the umbrella for all their little minions to do everything wrong, because that's what we're seeing. In a nutshell, that is what we're seeing. Anything that falls back on MERS is just going to point and says, well, they did it. The signing agreements they have with these over 20,000 certifying officers that you see signing all the documents, they literally, when they sign this agreement, they agree to indemnify MERS from all harm. This is a problem when you're looking at trying to build a case and MERS is involved in the equation. Because MERS all of a sudden has isolated itself up here, and it's frankly just a bad business model. It's flawed and it's fatally defective. And it's going to be the downfall of the land records unless they rise up and do something about it.
MERS only has about 70 employees, but they have over 20,000 people around the country who are signing documents as if they are officers of MERS. That kind of system is a recipe for a lack of accountability. You have a bunch of, untrained loan vigilantes, and they're signing documents. They don't have any idea what's going on. They're taking away people's property rights without following up on it, and they're not properly supervised. Like you said, Dave, it's a fatally flawed business model.
You would like to think that wire fraud would be a potential issue. But the problem is when the U.S. Attorney's Office and the Attorney General used to work for, Lanny Brewer and Eric Holder both worked for Covington and Burling. Covington and Burling was the business model for MERS. They endorsed it. MERS went out and got Moody's Investor Service to write a glowing recommendation about how MERS is going to streamline everything. They got Moody's, Fitch's, and Standard & Poor's, and Standard & Poor's and McGraw-Hill are now being sued by the people of Illinois for misrepresenting themselves in all of these ratings. Because come to find out, the ratings that they gave AAA to were nothing more than junk bonds. And so now they're wondering why all these loans are going to default. And also the investor pools are coming back, many of which are your own 401ks. Teachers' retirement unions, plumbers and pipe fitters unions are now coming back in droves and suing the trustees and the trust for basically misrepresentation and fraud on the prospectus. That's all they can do. So, we're seeing it happen on the other end, and we're looking at this end and saying, okay, you can kind of put the system together, and a lot of homeowners are trying to use securitization arguments to go in, and the only ones that are winning right now are challenges to noncompliance on the PSA. When I was on stage with Mark Dan, the former Ohio Attorney General, he was saying that the biggest problem homeowners have that are addressing now, and this is coming directly from a former AG that's right in the thick of this as a foreclosure defense attorney, that one of the biggest peeves he has is that homeowners get led astray by these $9 an hour cubicle lawyers who are not lawyers, but they think they're lawyers. They're giving legal advice. They're telling homeowners, stop making your payments for 90 days so you can go in default and then we can do a loan mod. Well, excuse me, but when you do this, when you stop paying on your loan, you immediately go into default. And when you go into default, then they start the foreclosure proceeding, and this, loan mods at that point in time are useless in my book.
Yes. Do not stop paying your mortgage just because you have doubts about this. I have talked to people who have done that because Hey, we don't know who owns it, so we're going to stop paying our mortgage. That is a recipe for trouble. If at all possible, stay current on your mortgage and find out who the proper party is. You can get that straightened out later, but it's a lot harder to do after you've been evicted out of your house.
The problem with the homeowner's policies as well is if there are certain defects that aren't cured beforehand, that aren't in the land records, they're excluded from coverage. You're not going to get it. I've owned enough homes, as have you, to understand, the basic tenets. Once you understand how to interpret these title policies, most homeowners understand that these have very limited coverage, and they know this. But the way the system is played, you have to have title coverage, and the title company has to do, their job, to prepare the documents for closing, and that includes doing a run-up.
The County and District Clerks Association does have a legislative committee, and we're going to try to have that section of the law repealed that allowed for MERS. That was put into the law in 2003.
It's 51.0001. It's National Book Entry System definition.
In the Texas Property Code.
The property code.
And the Clerks Association has a bill to amend that, and I think that's good legislation and worth your support.
Because when you're dealing in a non-mom loan, and MOM is an acronym for MERS-originated mortgage, when you're dealing in a non-mom loan and all of a sudden it transfers into the MOM system because some lender sold it to another lender who securitized it, put it in the MERS system, and their database now has it. At that point in time, when it became a MOM loan, all of a sudden your chain of title, the issues with corruption of title started to happen because of all the transfers that were taking place on Wall Street that weren't being recorded in the land records. Unbeknownst to the homeowner, the non-mom issue, they think that they're just paying the same servicer they were paying for the non-mom loan all this time. When the mom loan is out there floating around in the ozone, you don't know who the servicer is paying the money to. And again, as I mentioned before, the only way that a homeowner would actually find out who the real claimants and interest are in his party is to stop making your payments. And that's unconscionable. I can't do that. I don't know of an attorney that would ever tell anybody to stop making their payments, because they don't want to see that kind of grief brought on them. But, frankly, there are people that have been in their houses, we call them zombie homeowners. They've been in their houses for 5 or 6 or 7 years without making a mortgage payment because nobody's come forward. So now we get this big legal issue going on. This is all created by the fact that the banks don't follow their own processes. And then they let MERS and their minions underneath the umbrella that I was talking about in Commissioner's Court this morning, totally unfettered, totally unregulated, just run roughshod all over the land records. And so over half the land records in Williamson County, in my estimation, are totally corrupted. And I think that Mrs. Reister's office is probably well more than several $1 million in the hole instead of just one because of all of this. Because we don't know, as far as securitization, how many times the notes were transferred, how many times they should have recorded the assignments in the land records. This is almost kind of like what people tell you, go online every 6 months and check your credit bureaus, pull your credit bureaus and look at your credit scores. This is almost the same thing. It does not hurt to go down to the land records and examine your documents and see what's going on. I teach classes to people to do chain of title assessments so that they kind of understand the core of everything that we present in this audit. So, it's one of these things that now it's becoming a necessary element of society because of everything that MERS has done in the last 13 and a half years.
It's not something that we really wanted to know. We knew it was happening. And it's kind of like finding out your husband's cheating on you. The next step is, after you've recovered from being stunned, what do you do? And so the Better Business Bureau is a good thing for homeowners to do after they've researched our records and looked to see on the assignments what all has happened to their note. If they have more questions and their lender is not answering their questions, then they need to look to an attorney.
It's coming, guys. We're gaining ground. And the facts are these. I want to just highlight a couple of things that were said in this particular video. And that is, they talked about the banks don't even know if they own the loan. they contact the bank and they don't know what's going on. And the fact of the matter is, that's exactly what's happened to me. I've had a contact tell me